Three, two, one. Welcome to another installment of Empowered Esquire TV. Today we have an amazing, wonderful show set up for you today with an amazing, esteemed guest. Let me just give a quick hello to everyone in the chat. I hope everyone is having a wonderful Friday. Let me go ahead and give you kind of my forewarnings. As you may have heard during the intro music, I was in the background saying, today of all days, something is going on with the weather today. And so my internet is acting crazy due to the weather. So bear with us. I know it's been a moment since we've seen each other. And, you know, there's been a lot going on and my family suffered a loss. And so really, I just wasn't up to going live earlier this week, you know, but I'm here with you now. I'm happy to be here. Hi to everyone in the chat. Thank you so much for taking the time out of your day to be here today. So for those of you who maybe are unaware, right? Michael Nowak, sometimes known as Polight or Brother Polight, has had a updated information filed in his case. In other words, the charges have been updated and there have been charges added. So what we will do today is walk through the disposition chart in his case. So walk through what has happened from day one until now, and then walk through the new charges, talk about, you know, the potential prison time, and also break down what these charges mean, as I did for you in the very first case review of this case. Now, some of you have asked if I will follow this case. Absolutely. I will continue to follow this case all the way through until the end, whatever that end may be. Now, on that topic, I like to say, as an attorney, I do not predict how cases will turn out. And I do not recommend that anyone online try to predict how a case will turn out either. And here is why. Cases are unpredictable, especially if this case ends up going to a jury trial. You can never predict how a jury trial will turn out. Some people are saying it is possible that he could be acquitted. Yes, those people are right. If this case is sent to a jury may look at this evidence, and despite what other people think, they may think, you know what? I don't think so. You never know what could happen in a court of law. So I do not recommend anyone predicting what could happen. Now, in my professional opinion, I tell you all the different potential outcomes. But as far as forecasting an outcome, I would not do that. And I do not recommend it. Okay. Someone said their condolences to my family. Thank you so much. Candy Girl says, smash that like button. I agree. If you are in the building and you're enjoying the content, please hit the like button. It is totally free. All right. So as you got a short glimpse of earlier per my, StreamYard foolishness, we have an esteemed guest today. He calls himself a junior elder, which, hey, I think I might actually agree with. And there's not many people who can give themselves the elder title, and I'll agree. But I really would say that the best title to give to him is a truth teller. He's been, as a leader online, telling people really the truth and the science behind a lot of pop culture issues. He's live on his channel tonight, I believe 7 p.m. California time, with another riveting topic. So without further ado, everyone, welcome Chief X, also known as the God Best Reincarnated.
Thank you.
It's an honor to have you here today. We're all so just ecstatic to have you here. It's a real treat.
Thank you for the introduction, and I'm glad to be here. I love your teaching moments, and I'm just glad to be here and share this stage with you, and put in my input when necessary, and reveal some questions to you. And I highly, highly suggest everyone that is listening to this video, share the video. Share it anywhere you want, share it in groups, share it with your friends, and let's have this discussion and talk, and listen to the teacher, Phyliciadcpearson. She does such an amazing job. And when I first ran across her, I was just very, 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 very impressed with the way she conveyed the information. And we're gonna do this today.
We're going to do this today. Afrocentric Beauty says, I finally caught a live. Yay! So glad you caught us. This might be our new time, everyone, because I actually think I prefer this to Sunday. All righty. All right. So listen, we're early on in the stream and I already blocked someone. People, if you want to be here and you want to participate in the stream, please be respectful to everyone present, or you'll get sent to the blocketh. And I am not the kind of person that unblocks once you are blocked. You are blocked in perpetuity. All right, shout out to Pocket Watching with JT, an awesome content creator here on YouTube. I mean, superb, okay? Thank you for the super chat. And man, I'm honored to know that I'm one of your faves. What an honor.
All right. I love Pocket Watching with JT.
Oh, I love him. I love him. And also he's my frat. So, hey frat, how you doing? So let's jump into the Miami-Dade clerk's office and their record of what has happened in this case. After that, we will dive into these new charges. Okay. All right. So you guys know, per usual, for some reason, I tend to announce when I'm sharing my screen. Why? I don't know. I just do. So share screen. Here we are. Miami-Dade County Clerk of the Courts, right? Criminal Justice Online System. You see all this information in the beginning. You see Michael Nowak. You see the date this case was initiated, right? All this stuff that lets you know you're looking at the case that you're actually trying to look for, okay? So let's go past charges for a moment and let's just go here to docket, right? This is the docket report. So you can start from the very beginning here, August 17th. August 17th, you see a charging document was filed, right? And so an arraignment hearing was scheduled for September 15th. They have that it was assigned to the intake unit for these certain types of crimes, right? They have that a prosecutor was assigned by the name of Nicole Garcia, right? And then they also have that Mr. Adam Rosen, Esquire, was given a notice of the hearing as he is the defense attorney of record in this case. August 18th, demand for discovery. probably filed by Mr. Rosen or Rossen, right? Because it is commonplace for a criminal defense attorney to file a motion to dismiss, as you see here, and a demand for discovery right away. Sometimes that is referred to as an omnibus motion, right? It's an all-encompassing motion. But it is commonplace for the minute a defense attorney is retained, they say, all right, let me file my demands. Let me file my motion to dismiss. Now, here's the thing. Do they think that the case will actually be dismissed? Maybe not. But to protect themselves from malpractice, it is commonplace for every criminal defense attorney to file a motion to dismiss. Because even if they don't think they could actually win it, a client can later on turn around and say, you never filed one, and I think we could have won it, and so I think that's malpractice, right? And then that attorney could end up tied up in court trying to explain why they did not file that motion to dismiss, okay? Now we have all the bail and bond things that happened. And now we get to September 14th and we see information filed. So we know that there's been an updated charging document. There's been updated information filed as of September 14th. Now, September 15th, we see motion for stay-away order filed. So this motion was more than likely filed by the government requesting that an order to stay away from the victim and maybe her mother be entered by the judge. Now, a stay-away order is pretty much the same as an order of protection or a restraining order, right? And in this type of case, these orders are commonplace to protect the alleged victim. Now, you see that that motion is set to be heard on September 17th, which is today, at 10:30 a.m. You see there's also a motion to increase bond. So there's also a motion, along with these new charges, there's also a motion to increase the bail amount set for today, okay? Now, when you look at a motion to increase a bail amount in combination with new charges being filed, you could legally say, well, that insinuates that the prosecutors feel pretty strongly about this case, right? They've added more charges, and they're also saying, we want higher bond. And we see a motion for continuance filed, and that just means that the case was adjourned to a new date. And then they have a status conference set for December 3rd. So more than likely what will happen on December 3rd is the judge will say to each side of the case, are you ready for a trial? And each side of the case will have an answer. Now, it could be, Judge, neither of us are ready. We're still in motion practice. I'm still responding to motions. Or it could be, Judge, we are ready. Or perhaps one side of the case is ready and another isn't, right? There's tons of different outcomes there for a status conference, okay? So I'm going to stop sharing for a moment, hop back into the chat so that I can answer any questions. Chief X, do you have anything you'd like to say about that disposition chart? Chief X, you muted yourself, so I can't unmute you.
Okay, I'm unmuted. No, I don't really, but people are saying that they upped the bail to $46,000 just recently.
So as I said, filing a motion to increase bail shows that they feel pretty strongly about the case. And by they, I mean the government. And allegedly, the judge agrees, and bail has been increased to $46,000 or $47,000 based upon, what numbers you're working with. So that does say, yes, Chief.
I'm raising my hand like I'm in class.
Yes.
You said government several times. Do you mean state? Or are you saying, when you say government, what do you mean?
Oh, government means prosecution. Government means the state of Florida. Okay. I use those terms interchangeably. So I could say government, I could say the state, I could say the prosecutor, and they all mean the same thing. All righty. So yes, that shows that they feel very strongly about this case, and that the extra charges, the additional charges they have filed, in their opinion, has actually made their case more detailed and more strong. So let me see. I'm looking in the chat to see if any of you have any questions about the disposition chart. Not charges, not what I ate for lunch yesterday, the disposition chart / docket report that we just looked at. All righty. I do not see any questions about that. So we're going to move on into these charges. Now, I will say this. Someone gave an opinion about the prosecutor in this case. I will say that I do not recommend giving your personal opinions about the veracity of either the prosecutor or the criminal defense attorney. And here's why I will say that. You cannot look at someone in a, isolated court appearance and judge how accurate or how efficient of an attorney they are. You do not know from watching one court hearing with someone whether or not they are a good attorney. They could have had a headache. They could have had a bad day. And let me tell you why I know that. I know that because I have won cases against people who underestimated me. Because the first time they saw me, I had a headache or a stomach ache or whatever, right? So do not look at one hearing and see this young lady, which I think the prosecutor is a woman, right? And think that you can now make this vast judgment as to how efficient she is. You may be wrong, okay? All right. And so someone says, so is the attorney from the mom or the state? Let me clarify that because I think I understand what you're getting at here. So the child / victim in this case is not being represented by either the prosecution or the defense attorney. Now, in the future, a guardian ad litem or someone of some sort could step into this case and kind of represent her interest, but the prosecution represents the interest of the state of Florida. And that is how it works in every prosecution. A prosecutor is never representing a victim. They are representing the interest of the state or the United States of America if they are a federal prosecutor.
Yes, because some people were wondering why didn't it say Polight versus the victim? They were asking. So the state versus Polight.
I would have explained that, but whoa, I didn't know that's where we were. I didn't know I had to explain that. Okay, let's walk it back some. So when you're in a prosecution, in a criminal case, it is the place in which you violated a law, allegedly, that is prosecuting you. It is not the victim prosecuting you. So it would be the state of whatever versus the defendant, or the United States of America versus the defendant. The victim themselves is not the person who is going to prosecute the alleged defendant. And to illustrate that point, a lot of times victims will not want to go forward with charges. Victims will say, I don't want to press charges. And the state will say, we don't care. We're charging the person anyway, because the state is not an attorney for the victim. The state is the state. They are charging this person because this person violated their laws, not because of the victim in any special matter or manner. Okay. What do you think about that, Chief?
I totally agree. It sounds appropriate. A lot of people have questions, but most of their questions are regarding the charges. So I guess we'll wait for you to go over that.
Yeah. We're gonna get into it. But I want to make sure that we understand everything else, because if we don't understand the state versus Michael Nowak, we're not gonna get the charges. Won't make any sense, right?
Right.
All right. So let's jump into the charges now. Okay, so we're going back to our same page here. See, the docket report is down here. Now, if you scroll up, you see the charges. Now, I'm going to start from the portion of this that I know all of you are just absolutely dying to hear me clarify, right? I already know. So let's start from that portion, shall we? Down here at the bottom, you see the 2 felonies that were initially charged along with this misdemeanor. And here you see no action as the disposition. So people, no action is legally different from an outright dismissal. Let me explain what no action means when you're talking about a felony. So no action means that no further information was filed on those charges and or no grand jury action occurred addressing those charges. So it could either mean that when they filed the new information, they didn't speak to those charges, or that they did not take those charges to a grand jury of any sort. Okay. So why is it different from an outright dismissal? Here is why. No action thus far does not mean that those charges are necessarily dead. Now, we all have the right to a speedy trial. That's a constitutional right. So depending on how much time the prosecution has left, they could decide to take further action on those charges if they still have speedy trial time. So that is why a dismissal is different from no action. A dismissal is this is dead, this is done. No action could be revived if you still have time left on your speedy trial clock. Okay? So that is why it's a legal difference between no action and dismissal. Okay, so let's hop back into the charges now. So we see contributing to the delinquency of a minor. We've already addressed that. But here we see 4 new felonious charges. So we see L&L mole child. What does that mean? We see L&L conduct child and L&L exhibit. Okay. So L&L sounds L&L stands for lewd and lascivious. And per usual, we are going to go onto Online Sunshine and look at the actual statute for all of the lewd and lascivious offenses and talk about potential prison time. Okay, we're going to break it down just like I did in the very first video. Okay, so before we do that, let me see if Chief X or any of you have questions about the new charges. Yes, Chief.
Yes, so people are a little confused about the charges. They, as she said, they are still live. So, which I think you're saying they can be visited or revisited throughout the case. Maybe some more information may come out during the process and they can revisit those.
So what I'm saying is, and mind you, there's two outcomes here. No action could mean that the government chooses to never take action on those charges again. It could mean that those charges are dead. However, it's not the same as a dismissal because it doesn't mandate that they're dead. If they still have time on their speedy trial clock, they could revisit those charges. That is why it's legally different from an outright dismissal. Does that make more sense?
Yes, they seem a little, they have some clarity now.
So Nappy Yankee has a question we're going to address. Hello to Nappy Yankee, by the way. Nappy Yankee wants to know, is there a possibility that the two charges were dropped because Polight talked the mother down? If so, could the mother herself be pressured or catch charges? So to answer your question again, nothing was dropped. Dropped is not the right legal term to use because there is a difference between dismissal and no action. So dropped is not really the proper term, right? Is it possible that Polight has had contact with the mother? Who knows? I mean, maybe. There's really no way for any of us to know that. Could the mother herself incur charges? I think that's very unlikely at this point because she seems to have been instrumental in this incident being reported. And usually the law will view that as you did what you could as a parent. You took your child to report it, you took an action. Okay? Anything on that, Chief?
Yes. People were questioning also the stay away order. And that's usually, I guess, put in place because to stop the interaction between Polight and the lady or child. Some say he's made some innuendos on some Instagram videos, trying to subliminally communicate with the lady. And they're just wondering, is that a reason why they may have a stay away order, or why didn't they have a stay away order in effect previously?
Okay. So quite frankly, with this type of case, if I were involved, I would have requested a stay away order immediately. Why a stay away order was not requested immediately, I don't know. But as I said, a stay away order in this type of case is commonplace. It is common to order that the defendant stay away from the alleged victim. That's typical. And a stay away order is pretty much the same legally as a restraining order or a protection order. It says, stay away from this person, stay away from their home, stay away from their school, stay away from their work, right? Et cetera, et cetera. We good on that one, Chief?
Yes, ma'am.
Okay, so there's a comment that I want to highlight. So, oh, wait, first, let me shout out the super chat. My goodness. How could I forget? Thank you, CJ, AKA, for the $5 super chat. We appreciate it. All righty, now we have a wonderful viewer saying the clerk's office says, based on the information filed on September 14th, that the state did a no action because they did not have enough evidence. That's possible. So it's possible that they took no action, as I said, because at this time they don't have the evidence. And depending on the time on their speedy trial clock, they may develop evidence and decide to take action on those cases. Or it may be dead. They may decide to never review or address those charges ever again. You never know. But it is legally different from an outright dismissal. Okay? Chief, you got anything on that?
No, I believe that is understood. No one has any questions on that. I have clarity.
Okay, all righty. So per our last episode, you guys know that I dove into each of the charges with an explanation of what the charges mean and the potential prison time for each of those charges. Okay, so we're going to do that as well. Before we do so, Claymore has a good question. Claymore wants to know, does that mean that Polight also can't contact her through a third party? Ding, ding, ding. Claymore, you might be the winner of the live thus far. I love thought-provoking questions. Yes. When someone has a stay away order or a restraining order or an order of protection, that person cannot contact the victim through any means at all. They cannot say to Chief X, can you tell her I said, right? No. They cannot send messages through other people. They cannot contact that person at all. At all. Okay?
And if they do, that's cause for revoking the bail, correct?
Precisely. So this is why Chief X is here, everyone. Give it up for Chief X. Let's have a quick conversation about bail conditions. So usually part of the bail condition is that you do not commit further crimes. If you violate an order of protection or a stay away order or a restraining order, that is a crime. So yes, if a stay away order is issued and then Michael Nowak were to hypothetically violate the stay away order, that could be a condition for revoking his bail. Yes. We got another super chat. Hello to Queen's Throne, another awesome content creator here on YouTube. You should check her out. Thank you for the kudos and the compliment. It is well received by my guest and I. All right, so let's dive into my notes. You guys know I always make little notes for you, and then I walk you through them, right? All right, so per usual, I have to announce that I'm sharing my screen. Why? I don't know. All right, and I kept it all in the same document. So you will see, well, you may see the prior charges as well as I kind of scroll down to the recent charges, okay? All right, you can see my screen. Great, let me take the super chat down. All right. And I wonder, should we make this full screen or would you still like to see me and Chief? Let's see. It doesn't make much of a difference. You can still look at us. All righty. So here we go in our doc. Let's start from the beginning, shall we? New charges. Okay. So the new charges, the new charges are all lewd and lascivious offenses. Oh, you know what? I wanted to show you Online Sunshine. So you know what? We'll do it in reverse. We'll walk through this first, and then I'll show you Online Sunshine. How about that? Okay. Alrighty. So this is all pulled from the state of Florida Online Sunshine statutes. Okay. So this is directly from the statutes.
And everyone, no one can pronounce the word except you. Lascivious.
Lascivious. It's lewd and lascivious. If pronouncing words is not your thing, I would recommend doing a lot of reading. I did a lot of reading growing up, and then words just became my thing, right? And another thing you gain with that is languages become your thing too. So yeah, reading is great. It's fundamental. All right, here we go. So lewd and lascivious, a lewd and lascivious offense is when a person intentionally touches a blank, I try to stay away from certain words, under 16 years of age in a lewd or lascivious manner, or solicits a blank under 16 years of age to commit a lewd or lascivious act. Pause. So this means that a person does something intimately inappropriate to a minor or tries to do that via soliciting the minor to do those things. Now, the direct definition of lewd and lascivious is just wicked, lustful, unchaste, licentious, or sensual. That all amounts to intimate, right? The S word that we also don't use on this channel. That's what it all amounts to. Now, these types of charges are strict liability charges. For those of you who don't know what that means that there is no reason that can be used to try to wiggle out of or defend yourself against this charge. When a charge is a strict liability charge, the only defense that's really left available for the defendant is to say that it never happened at all. So one more time, when a charge is strict liability, the government is saying it really does not matter what your reason is for this happening. And so really the only defense to this type of crime is to say that the act never occurred at all, that it never happened at all. Let's get into it. So strict liability, lewd or lascivious conduct is a strict liability crime, which means it does not matter if the child's real age was unknown. So it doesn't matter if the alleged defendant did not know how old the child really was, or the child consented to the conduct. It also does not matter if this defendant tries to argue that the minor said okay, or the minor consented in some way. Okay, neither of those things matter because it is strict liability. So let me look in the chat here, see if we have any questions thus far about that. Let's see. Oh, we have a good comment here. So P. Fowler says, I listened to the case on Zoom. So sad he was still contacting the victim according to the prosecution. Oh, wow. Horrible. So we have an allegation here that Michael Nowak was allegedly contacting the alleged victim. Wow. Okay, that was not smart. And that could be the reason that the stay away order was then finally requested.
Yeah, that seems very dangerous and stupid to do. And but that's Polight's personality. He feels he can talk anyone into or out of anything.
Yeah, I'm taken aback by that. I would imagine that his attorneys advised him not to contact her. That's what I would imagine, because were it my client, that is what I would have done. So perhaps he went against the advice of his attorneys on that. Okay. Some person said, Aku Cromanti said, is it even possible that it was the mother's shirt and scarf? We don't know. Anything's possible. Maybe it was the mother's shirt and scarf. We don't know, right? These are things that we'll have to let the case develop. All right, so I'm diving for questions. I do not see any thus far. So Chief X, do you have any commentary or questions you'd like to add on lewd and lascivious conduct and on strict liability?
No, I do have a question, but you're going over the charge in order. And my question and some other people's question was why the charge was on there twice.
Okay, that is a very good question. So let me give you a random example, okay? If someone were to rob someone, right? Hypothetically, you have victim and then you have defendant. And let's say defendant robs victim, right? Let's say defendant takes a purse from victim, but also takes a duffel bag from victim. The prosecution could charge 2 charges of robbery. Why? Because there were 2 different items that were allegedly stolen. So in this instance, if the prosecution is alleging that they have multiple deposits of bodily fluid, they could say, well, Your Honor, we're charging separate counts for each deposit of bodily fluid based upon some sort of theory or version of events, which would say that it was different actions that caused the different deposits of bodily fluid. So that's one way, right? Another way is perhaps the version of events that they received from the victim did actually involve 4 different actions. Perhaps within that one night, he did 4 separate things to this victim, allegedly, and each of those things account for each count of lewd and lascivious conduct. What you think, Chief?
Agreed. I agree with that. Go ahead.
So you see the 2 ways. It could either be deposits of bodily fluid, or it could be, you know, the victim actually recounted several different actions that occurred.
Yeah, because some people were also thinking that possibly another victim came forward and that was another charge, but we see that's not the case.
Right. I mean, you know, was that theoretically possible? Sure, but it doesn't look like that's the case. It doesn't appear that that's the case. Okay. Oh, I see a slew of questions in here. All right, so let's start just grabbing some. Let's see. What happened to the question that I wanted? Oh, no. Here we go. Red Spot says, is it possible that the prosecutors are looking for other victims? Yes. It is possible that, as I said in my very first review of this case, that the prosecutors are trying to dig into this person's past, into Michael Nowak, also known as Polight, to see if there are other victims. That is totally possible.
Now, question, that's similar to the Cosby case. Now, if they came across another victim, he's not charged in this specific case for that victim. So I guess the victim would become like a witness or a testifier.
That is correct. So if in fact they were to find other victims, which what happened to those victims aligned with what this victim alleges, right? Because remember, in order to get past the initial, there's an initial assumption in the court of law that something you allegedly did in the past cannot be used against you today. It's called propensity. So to get past that assumption, you have to establish modus operandi, which is a pattern of behavior. So if they find other victims who allege that, you know, Michael Nowak did similar things to them, you know, and they can say, oh, I see a pattern here, then they could pull a Cosby. They could bring in these victims that they're not even charging him with. These victims are not even on the charging document, but they could bring these victims in and have them testify to show the court that there's a pattern of behavior here.
Also in the chat, if you guys do type a question, can you use a question mark at the end of it?
Very, very good. Very, very good request. All righty. So I see someone saying, why did they drop the other charges? Hello to you, Tony Hayes. I see you just joined us. Go back to the beginning of the Go back to the beginning of the stream where we discuss what no action means. Nice to meet you, Tony. All right, so let's dive into potential penalties for these types of charges then, shall we? All right, so I'm back in the document here. Penalties for lewd or lascivious conduct, okay? So conduct by a person who is 18 years or older, right, that is considered to be lewd or lascivious conduct is a second-degree felony. Let me pause for a moment. There are allegations that Michael Nowak has come online to say that the most serious charges were dropped. Well, originally there was a first-degree felony active on this docket. As we now know, the active felonies are second-degree felonies. So technically, he's not necessarily totally off base with that comment, although it is a bit misleading in the way that it sounds, right? Okay, so second-degree felony, punishable by up to 15 years in prison. So as you can see, the initial felonies were up to 25 years. These felonies are up to 15 years. However, do not forget that there are 4 counts of this felony. So when you do the math, the potential prison time is not different. Okay? All right, punishable by up to 15 years in prison, 15 years of blank offender probation, and a $10,000 fine. Under Florida's criminal punishment code, conviction of L&L without prior criminal history or other mitigating circumstances carries a minimum sentence of 30 months in prison. So generally, it's a minimum of 30 months in prison and at least 2 years. Oh, wait, Chief has a question. Yes, Chief?
With these 4 new charges, does mitigating and aggravating apply to these?
So mitigating and aggravating applies to these charges as well. As we've discussed on this channel before, mitigating means to make less, to make not as bad. Aggravating means to make worse, which means to make even more severe. Some mitigating circumstances in this case could be if Michael Nowak does not have a prior criminal history, right? That's considered to be mitigating. And perhaps if they can prove that there are other mitigating circumstances, such as perhaps interactions between him and the victim. I don't know what those interactions would look like, right? And another mitigating circumstance that a lot of courts consider is whether or not that person, so i.e. Michael Nowak, was abused as a child. A lot of courts consider that when a child was abused when they were growing and coming into form, it's possible they may turn around and become an abuser. And so some courts view that as mitigating. So if Michael Nowak does not have a criminal record, perhaps has a history of abuse in his own life when he was growing up, things like that, a court could look at and say, you know what, we're going to not punish you as harshly because we think that these are mitigating circumstances.
And in the state of Florida, I think before on the previous review you did, you said, according to the state of Florida, if convicted, you have to do the whole time in a case like this. There's no early release.
We're going to get to that. So on our doc, we're going to get into time. All right. So minimum of 30 months in prison and at least 2 years of blank offender probation. Okay. A person sentenced to prison for L&L is ineligible for game time and must serve the entirety of their prison sentence. One more time. Must serve the entirety of their prison sentence. So all the other ways in which inmates can gain time, whether it's good behavior or any other rigmarole they can do working for this entity or that entity, those things do not apply to these specific charges. These charges, if convicted, you have to serve day for day. Okay. I see in the chat there is something going on. Okay, you all in the chat, you need to be nice to each other. Okay, you need to be respectful, or again, you're going to get put in the blocketh, and the blocketh is perpetual. Okay, now back to the document. This conviction does render the convicted a blank offender, and the convicted would be required to comply with blank offender registration laws in Florida and throughout the US for the remainder of their lives. So if Michael Nowak is convicted of any of these 4 felonies, he would have to register as a blank offender, and he would have to continue to do so for the rest of his life. Chief, anything?
How does that affect a person's parenting?
Wow. Well, let's first talk about how it affects your life. Okay, so first things first, the blank offender registry is public because the government believes that parents have the right to know where these types of offenders are living. So the first thing is that wherever he were to move to, if convicted of this, and if he had to register, of course, right, people would know that he's a blank offender and that he's living at such and such place. His place of residence would always be public. He could not try to privatize where he's living unless he were, of course, violating the rules, which if you want to know what happens when you violate the rules, check what's going on with Nicki Minaj's husband. So he would have to register, meaning people would always know where he's living. And he would be restricted from living in certain places, being in certain places, right? Places that are near schools, places that are near places where minors gather. He would be prohibited from living near or being around those places. It would undoubtedly change his life if he were to have to register as a blank offender. Anything on that, Chief?
No, but somebody is concerned that Polight did travel in and out the state or in and out the country with the mother. I never seen the child with Polight and the mother, but people were asking, but it's not one of the charges, but people were asking, could they add transporting across state lines?
Yes. So when you want to add something such as transporting across state lines, such as in R. Kelly's case, right? You have to specifically detail that the conduct occurred. So you have to say that allegedly this person transported this girl for the purpose of doing this or that to her, or that while he was transporting this girl, he did this or that to her, right? So just traveling with this girl in general doesn't mean that any crime was committed. It has to be that the crime was committed during or in tandem with or in relation to the transportation of the young lady.
Someone's asking, can you speak to regarding his presence in court? Why didn't he or did he not have to appear in court? And I guess in these early proceedings, your attorney can just appear for you.
So in case you all have missed it, we're in a global pandemic. I don't know, maybe you missed that, but we are in a global pandemic, and the criminal court system has also made adjustments due to the pandemic. They have stopped requiring that everyone appear in person all the time. They started restricting in-person appearances. They started doing a lot of electronic appearances, and also they've started to allow a lot of attorneys in lieu of defendant appearances. Got anything else for me, Chief?
That's about it.
All right, I see a good question here. Someone says, what about the children that are in their custody? Assuming that there means in the custody of Michael Nowak and his girlfriends or wives, I think that the state of Florida will probably do their own investigation on that, right? To our knowledge, the other children don't live in the state of Florida. We could be wrong on that, right? But public belief is that the other children live in the state of California. So the state of Florida may do a quick investigation. You know, they have their own Department of Children's Services. So they may do an investigation to see, well, are there other minors attached to this defendant that live in the state of Florida? And perhaps if they find that there are minors who live in the state of Florida, they may restrict his connection to those minors, right? So they may say, you know, we're not sure that it's safe for you to be around these minors. But that would all depend on whether or not the minors live in the state of Florida, because if they live elsewhere, then that would be the problem of that state, right? Then California would have to deal with that. Chief, do you know anything about California Children's Services and how they do their thing?
Yeah, you know, I used to work at Edelman's Children's Court in Monterey Park, California. It's a dependency court. All forms of child abuse go to Edelman's Children's Court. And usually, I mean, I've never seen otherwise, but if a man is convicted of a crime like this, Children's Services get involved. They take the children, and you know, it's about their safety. The children are questioned and all that. So, you know, it's another part of this case that a lot of people haven't been talking about. How does Children's Services play into Polight's case? And, you know, I would think the children are not in the custody of Polight and his wife right now until this case is over. That's what I would think, but I don't have information on that. But that's just seems like the normal modus operandi.
All righty, so I see a question from someone. I hope I don't butcher your name, but Lanhala Gadi. Woo, hope I didn't butcher that. She says, insofar as someone who is not able to pay their bail or bond. So I'm assuming that you're wondering what happens to someone when they can't pay their bail. Go back to my original video on this case, my first The State of Florida v. Brother Polight video, which I think I'll put in the description for you. So check back a little later. And we have a bail conversation in that video. We also have a further bail conversation in my video with Zion Lex. Okay. All righty. So let's talk about online sunshine and the actual statute. Okay, so now I'm going to share my screen. I'm going to remove that for a moment. While I share my screen for the actual statutes, Chief, do you have anything that you just like to say to the audience? Anything you'd like to add?
Yes, you know, I'm not an expert like you, but I think people's confusion with the sexual battery, I think may need to be addressed because people feel because she wasn't penetrated vaginally or anally, it's not sexual battery. But people forget oral is also included with vaginal and anal penetration. And on the police report, it does say he pulled out his blank and pushed her head towards it. So when we talk about revisiting the old charges, that could be a reason they could revisit it. If throughout this, they found out that there was some kind of oral copulation, correct?
Yes. So any type of inappropriate conduct with a minor is a crime in every state in the US. And oral contact is still considered to be inappropriate intimate conduct. It doesn't matter if it didn't involve the minor's nether regions. Okay. I do want to address this question here. So True Colors. Why is he still getting bail? Go back to my original videos where I explain bail. Bail has nothing to do with innocence or guilt. Bail has nothing to do with the strength of a case. A person is always assumed innocent until proven guilty. So that in itself should let you know that bail and innocence are not attached. Okay, so you can go back to my first videos and it will explain to you what bail is and how bail works. I have 2 videos. I'll probably turn it into a playlist or something for you, but I have 2 prior videos in my coverage of this case. Okay, so let's go to Online Sunshine, shall we? I have it pulled up here. If you're new here, welcome. This is Online Sunshine. This is how you can view any law, any statute, anything in the state of Florida, right?
And before you get started, I think people need to hit that like button. And if you're not a subscriber, I don't know why you're not subscribed yet. Just walk on over to the subscribe button and hit subscribe and follow Felicia Pearson, the wonderful Felicia Pearson.
Thank you so much, Chief. And I concur. If you are not subscribed, go ahead and subscribe so you can get all of the legal content that I share on this channel. And also make sure you're getting notifications so you know when I go live, right? You know, I come to you with legal knowledge, with practical legal knowledge. And I also bring on awesome guests like Chief X so we can have conversations like this, right? We focus on logic here. Not taking sides, not bashing people, not gossip, right? Logic, all right? I see someone made a comment. So P. Fowler says, in the Zoom court this morning, the prosecution stated clerical error as to why he was out when he was supposed to have no bail. Okay, so this person is insinuating that they actually were in the Zoom meeting or saw the Zoom meeting somehow, okay? And so is it possible that the prosecution said that there was a clerical error as to why Michael Nowak was granted bail? That's possible, but that doesn't change the law of how bail works, okay? The state of Florida themselves have written several statutes that explain how bail works, and bail still does not have anything to do with guilt or innocence. But it's possible that a clerical error could have occurred. That's totally possible, P. Fowler. All right, so I'm just scrolling for questions. All righty. So now Nappy Yankee, he says it, thumbs up, subscribe, and share. So here we are in online sunshine, okay? Now, I have actually pulled up the section or the chapter of the Florida statutes that deal with lewd and lascivious offenses. So this is a chapter here, everyone. They talk about the definitions and then they go into the actual statutes, right? So let's take it from the top. We're not going to go through the entire statute because I already pulled the pertinent portions for you in my doc. But let's talk about a few of these definitions because I think a lot of them are relevant to what Chief has been saying.
And before you talk about it, I just want to say to the audience, we're getting a lot of information here. We're learning a lot. She's sharing her time and educating us on the legal process of this case. She has her Cash App. You guys should donate to this lady. She has her Cash App up, and it's just a form of saying thank you for sharing with us in the community and keeping us informed. I think she deserves, send her a Cash App. Be nice and appreciative.
Thank you, Chief X. You guys know I was reluctant to start sharing my Cash App because I didn't want people to feel pressured, but I welcome any donation, whether it's $1, $2, whatever, if you're choosing to give from your heart, I welcome that, right? Just know that, and know that any amount is appreciated. You're not pressured, okay? And thank you to everyone in the chat who's saying that they appreciate the information. I'm glad to hear that. That's why we're here. We're here for the edification of each other. When I cover these cases, it's not mean-spirited. It's from a place of edification. I want to see us more knowledgeable, educated, logical, right? Thriving in logical, rational behavior and not having conversations that are not at all rooted in the proper information. So that's why I'm here. That's why I do this, okay? So online sunshine. The very first definition is exactly what Chief has been talking about. So under the statute of lewd and lascivious offenses, the person is being charged with blank activity. Blank activity means oral, anal, or vaginal penetration by or union with the blank organ of another. Okay? So all of those activities are included and covered by this statute. Okay? They get into things like victim, which we already know what victim means, right? They specifically discuss ignorance or belief of victim's age. So for those of you who might be unfamiliar with these types of charges, it is typical for a defendant to allege that they did not know the child was underage, right? But as we know, L&L is strict liability, right? So it doesn't matter if the defendant didn't know. Let's see what the statute says in particular. The statute says the perpetrator's ignorance of the victim's age, the victim's misrepresentation of his or her age, or the perpetrator's bona fide belief of the victim's age cannot be raised as a defense in a prosecution under this section. Teaching moment. Here's a breakdown of what that means. Even if the victim tells the defendant that they are of age. So even if hypothetically somehow this victim told Michael Nowak she was 22, still wouldn't matter. Even if for some reason Michael Nowak thought she was over 18, still doesn't matter. It is strict liability. So those arguments are not going to be defenses. He cannot argue not knowing her age or thinking that her age was something other than what it actually is. All right. I'm back in the chat. I want to see if there are any questions here. Interesting. So Transparent has a good question. Let's talk about this. Transparent says, hey, what does it mean if proven not guilty and every content creator that gets proven guilty results in both or either civil or criminal charges of them on them, resulting in shutting down of their channels, et cetera, et cetera. So what I think Transparent is asking is the potential of channels being shut down if they make a prediction as to this case and that prediction turns out to be wrong. Now, I have covered on this channel on several different videos what defamation is. Now, in some of my prior videos on Michael Nowak, I discussed it briefly, but if you really want an in-depth combo about what defamation is, you should check out my video on Candace Owens and Kimberly Klasick, or my video on Tasha K and Cardi B, because Tasha K and Cardi B are having a litigation that directly refers to activity on YouTube, right? For defamation, false statement has to be proved. And a false statement is not an opinion. So just because someone has an opinion, as long as they present it as an opinion, that is not defamation, and that, to my knowledge, is not cause for having a channel removed, right? So an opinion on a criminal case, not enough for having a channel removed. That is not in and of itself defamation. And if you want more info on defamation and public figures and all of that, revisit my video on Cardi B and Tasha K, or my video on Candace Owens and Kimberly Klasick. All right, we got some super chats I want to highlight. Let me go down to the first one here. Oh no, did I miss it? Did it disappear? Oh, here it is. Demeta, thank you, Demeta. You are a queen as well, and I'm grateful to have you here. All right. Next super chat I want to highlight. All right, we have a super chat from Shug, the king of content, sends $5 and says, what can I do about being falsely accused of being a blank by people like blank and other YouTubers? So here is what I will say to you, blank, the king of content. If you have something that you would like to address with Chief X, I would recommend you do so directly, right? And if you feel that you have been defamed, I would recommend that you see an attorney. Okay. All right, I'm scrolling through the chat. We have another super chat from B Buccaneer. B Buccaneer says, Chief X, do you think that Michael Nowak is Polight's real name? Oh, and quickly, Nappy Yankee says, is my Cash App a little doggy? Yes, my Cash App is Felicia P. I'll put it up really quickly. And that little doggy that you see is actually my little baby Mac. If you're a newbie on this channel, you don't know Mac, but if you're an OG, you know, I have a little 4-pound Yorkie. He's almost 5 pounds now. He's putting on weight, you know, pandemic fluff. And he is just a little sweetheart. So yes, you'll see a cute little face. That is his face. Okay. And
let me answer that question for this guy. Mm-hmm. So because people have asked that, is that his real name, and do the court? This is court. The courts and the law has been doing this for years. They know how to get a person's real name. When you even get arrested, you get fingerprinted. Okay, your fingerprints match up and they figure out who you are without a doubt. They would never make any kind of mistake like that in a court case, having the person's name wrong. So Michael Nowak Jr. is his name.
All righty. Chief X has spoken. We have another super chat, $5 from GZ, says, thank you for using your voice and online platform to inform and fight for the blank of minors. Please report blank abuse. Yes. If you have been abused in any way, I know it's difficult to do so. I know, but I recommend that you report it. You know, I know it's hard to do so.
Also, people are and I don't know why people think this way, but this is not, they're asking about, is it possible that she could have showed him a fake ID and that he thought, this is not like some girl he meets on the street and she shows him a fake ID. No, he was dating and calling the mother of this child his wife. It's very clear he knows her age. So that wouldn't even be anything, you know, to dispute.
So that's nothing to dispute because it's strict liability. So as we've discussed in both our little notes and also directly from the statute, right? This case, these charges are strict liability. So even if he thought she was another age, it doesn't matter. And let me tell you what the policy is behind that. The government views adults as responsible for who they choose to have intimacy with. The government views it as your responsibility as an adult to verify the age of any individual you choose to become involved with. So it is strict liability. Even if he thought she was older, it still wouldn't matter. Strict liability.
And another guy says, nope, Polight mentioned his real name in front of the judge, and it was not Michael Nowak. He said Michael Eugene. So just for clarification, Eugene is his middle name. His name is Michael E. Nowak Jr. So if he just said Michael Eugene, maybe Polight is being tricky.
Maybe, or maybe for some reason he wanted to clarify his full name. You know, perhaps they had his full name wrong and he wanted to make sure they had the entire name. You never know. Okay. Black Anonymous says, shout out to Black Anonymous, by the way. He's also a content creator here on YouTube. What about jokes, parody, satire, etc. in regards to public figures? So as I've discussed in my videos on defamation, public figures do not have the same degree of privacy as your average citizen. The courts view public figures as a lot more open to satire, parody, jokes, opinion, right? Because they view it as you've put yourself out to the public. You've decided to become this public figure, so people should be permitted to discuss you. That's pretty much, you know, common sense to me. And that is also how the court views it. Okay, so I am looking through the chat here just to pull some questions. In the meantime, Chief X, do you have anything before I pull a couple more questions and we let you go?
Not really. I'm just boggled why people are looking for excuses to blame the girl or mother, or was she wearing the mother's shirt, and all these silly thoughts.
So I have an interesting thought for you all. Instead of becoming personally invested in a case that really has nothing to do with you, maybe if you were not personally invested, you could view it from a rational perspective. Novel idea, right? Do not become personally invested in these things. It is the state of Florida v. Michael Nowak, not the state of Florida v. you. Step back, be logical, be rational, and then you can view it from an impartial perspective. And you don't have to find yourself trying to finagle anything because you're just viewing it as an outside party, which is what you are, unless you are Michael Nowak. And if you are, we knew you were watching. All righty.
Can't believe somebody's saying, how do you verify her age?
We already discussed that. We've gone over strict liability so much that I'm a little concerned that so many people don't, you know, how many of you think that you might be with someone who's not the right age? You guys are making me a little concerned. I say that with love, okay? But I'm concerned. I'm concerned. Okay, so I don't think I see any other questions per se. So here's what we're going to do. We're going to put up this super chat and we're going to say to our wonderful guest, Chief X, AKA the God Best Reincarnated. Do you have any last words for our guests before we let you go on about your day?
You know, I would like everybody to be not reactionary, but be rational. You have to look at this stuff objectively. And, you know, I really appreciate Empire Esquire. I highly suggest people subscribe and hit the like button and hit the notifications all. And feel free to subscribe to my YouTube page. It's called Chief X.
Yes, I am subscribed to Chief X. So that in itself should let you know. If you
we're gonna have a very deep history discussion tonight at 7 p.m. Cali time on my page, Chief X.
Yes, so 7 p.m. tonight, California time. If you're Eastern like me, do your little calculations and figure it out. But go on over to Chief X, subscribe, and set your notifications, all right? Bye, Chief. It was a pleasure to have you here. See you
soon. Bye, lovely lady. Bye.
All righty, so Chief X has left the building. I want to thank Chloe James for the super chat. She sends $5 and says, if he has 100K stashed away, can he be deemed a flight risk? Yes, he can. He absolutely can. So if hypothetically, Michael Nowak does have access to $100,000 liquid, so not assets, right? But liquid $100,000 in an account where he can have access to it right now, yes, that can be used by the government to argue that he is a flight risk. And it may have been used by the government to get the higher amount of bail that they just secured. You never know. All right, so I'm in the chat just scrolling through, picking through comments. I don't really have anything else in Online Sunshine to show you because, as you know, we already went through my highlights of the statutes. So not really needed for us to check out anything else there. So we're just going to have a quick little combo, and probably within the next 10 minutes or so, I'll go ahead and head off. If you guys did want to continue to see Online Sunshine for some reason, I am going to copy and paste the link, the actual link to Online Sunshine. And you can put that into your browser and check it out. You know, browse their statutes, okay? All right, we have another super chat here from N. Muhammad. N. Muhammad says, can we contact the state attorney to give them some info they may not be privy to that'll help their case? And would they look at his social media? So if you feel that you have information that the government would be interested in and you choose to share that information, then you are free to do so. Remember, the government is supposed to be working in the interest of the people. So if you are a citizen who says, I have information that they should have and you want to share it, I'm sure they wouldn't mind that. Now, as to whether or not they're looking on his social media, I am almost pretty sure that whoever the assigned prosecutor is in this case has gone on to Facebook, Instagram. What else are people doing? Snapchat. You guys, I'm on none of these things, so I don't know. But whatever people are doing nowadays, TikTok, I'm sure they've gone on there and they're looking and they're checking it out. I'm almost certain, because most prosecutors would. We got another super chat from Jenna Law. Hope I didn't butcher that. Says, great work, Empress. Thank you very, very much. All right. I am going to continue, as I always do, just scrolling through, checking out any of the comments and questions in the chat. Tony Hayes would like to know, if you were his attorney, what would you argue in his defense? As we've discussed, there really is very limited viable offenses to this sort of alleged conduct because it is strict liability. So really, the only viable options left are to just try to argue that this never occurred at all. So more than likely, his attorney will try to argue that this never happened at all. That might be his best bet because of strict liability. All right, everyone. So as Nappy Yankee said, be sure to thumbs up, subscribe, and share. I'm going to share my Cash App in the chat again. We have a question from Ankh. Well, Ankh smokes coke off. Interesting. Ankh would like to know, if the accuser decides to rescind her accusations, will the state pick up the charges? So I discussed something called evidence-based prosecution. And the very, very first video I did in my coverage of this case, it is titled The State of Florida v. Brother Polight. You should check that out. And Mac would like to know, if Polight is found guilty on multiple charges, will the judge likely make Polight serve the time concurrently or consecutively? That depends. That decision is made in tandem with the prosecution's recommendation, as well as with the judge reviewing all of the factors in the case. So you never know. It could be consecutively, where he is literally serving every single day because it's one charge and then the next and then the next. Or it could be concurrent, where the time that he's serving is counted towards all charges that he is convicted of. All righty. So I do not. I see Black Anonymous said, I see I got some homework to do on the sisters channel. I'm assuming you mean my channel. And yes, if you're new here, you got some homework. You got to go check out part 1, which is the State of Florida v. Brother Polight. You got to check out part 2, which is the Q&A with Zion Lex, because we really delved into DNA and bail. And then you can come here and review this so you get the full picture of what's going on in this case. GZ says, I really thank you for covering this. You are welcome. So listen, everyone, we've been on for about an hour and 15. I don't really see any substantive questions in the chat thus far. If you have a question about charges, go back to the beginning of the stream, okay? So anywho, this has been another installment of Empowered Esquire TV, where we arm you with legal knowledge. I hope you feel powerful and educated by the information that was shared today. And I would like for you to go forth, right, and in your life and everything you do, and walk with that power. Know that you are worthy of respect and you're worthy of educating yourself with the right stuff. It has been a pleasure seeing you today and spending this time with you. If you're catching this on the replay, what say you? What do you think about these new charges? And do you have any questions for me? See you soon.